that when all witnesses, and they now ask that conductor, "Oh, yeah, come and drive, worship here present." I've seen my colleague, her worship, Dr. Parajay, other colleagues here present. Let me particularly recognize the presence of NBA members here. I was secretary of the branch, I was the vice chairman of the branch, I was the chairman of the branch, and a member for years. I used to lead the bar to confront the judges politely. Politely. Because by that time we'll be in court 9. But your morale will be doubtful when you are in court 11 and no register comes out to tell you my lord will sit or my lord will not sit. Then we said, we can't continue like this. Please, sir, tell us the time you will sit. Because one of the things we sell as lawyers is our time. We have searches we want to conduct, we have letters we want to write, we have meetings that we want to go and represent our client. Now, I found myself in that position. Do I have any excuse for not sitting 9? I don't have any excuse. Members of Kukumo Shoba, thank you for coming. This is a big surprise. Please stand up for recognition. Thank you very much. Mr. Rajai and others, this is a very shocking surprise. Deliberately, I did not make mention of it that I will have this thing in open court, very unlikely, because I used to talk. Thank you for coming. And at least some of the things that we will interrogate here, you'll be able to say whether what I am saying is true or not. They're great Nigerian students. Students of Faculty of Law. At a time, it was when I came to read law that I stopped student unionism. Because I was the only one there, the only Muslim from my community that had opportunity of coming to read law. And I reflected on what I did while I was at College of Education, the kind of activity. So if I should repeat that here, and I have the cause for the university to say, go back home. Oh, it will be a disgrace to that. Quietly, I did not participate. I now went back to the NAMLAS then, which I led until I left this faculty. I will have appealed on your behalf to the Vice Chancellor. The person I know, the Vice Chancellor that I know, that the President that I know, is not a person that used to be unnecessarily rigid. But I think his hands are tied. However, at my own level too, whatever I can do, I will still appeal to him on behalf of. The family of my Lord Honorable Justice Mustafa Akabi, I think I have 2 instances of meeting Baba. One was when I was in 300 level here, and Baba was to bow out of the judiciary. That was when the Court of Appeal Ilorin Judicial Division was established. And we were asked to go there as students. We were there and I listened to his speech. He said for years, some of his juniors were being elevated to Supreme Court and they left him and he never complained, not knowing that they wanted to use him to head that court, having seen the quality in him. And he said he did not regret. He never influenced his postage. And I remember he was telling members of the bench then, posted to, don't influence it, it may be blessing in disguise. And I remember I was asked that question at NJC. How many judicial divisions have Oyo State? I mentioned the one I remember. Which of the divisions can't you work? I said, as a lawyer, I've appeared in Katsina, I've appeared in Kano, I've appeared in Jos, I've appeared in Abuja. If as a lawyer I can traverse the length and breadth of Nigeria, Oyo State is small. There is no judicial division I cannot work. If it's a judicial division of life. That's the type of person. And I remember, in the course of one of our private discussions with my mentor, Professor Akobi, I remember he told me when he wanted to serve during his NYSC. I think it was to serve at CBN. And when they heard that, oh, the son of then President of Korowaku, just go and get the notes that we identify you that you are from Baba, you are his son. And that was the note that Baba Mustafa Akobi will not write. If they want to give you, they find you worthy of working with them, they should, not because of my influence. That is the type of person that we have in Baba Mustafa Akobi. May he so continue to rest in peace. Ladies and gentlemen, the gentlemen of the press, please, whatever I say, please don't blow them out of context. Please, our job is very, very sensitive. Whatever we say is very, very, it will attack weight. A judge is saying this, a judge is saying this. But I will not say because of that, I won't say the truth. Ladies and gentlemen, I consider it a singular honor and privilege to be invited to this esteemed event of the annual public lecture in honor of a distinguished jury. Honorable Justice Muhammad Mustafa Adebayo Akanbi of Blessed Memory, presenting in this setting, does not only allow for the dissemination of knowledge, but also fosters meaningful dialogue among the participants. It's a chance to connect with individuals who share a passion for the subject matter of this discourse. As we delve into the topic of this presentation, we embrace the responsibility to inspire thought, to provoke discussion, and to contribute to the ongoing conversation surrounding the need to accelerate adoption of artificial intelligence in practical, life-improving solutions, particularly on access to justice. Let me state from the outset that Honorable Justice Muhammad Mustafa Adebayo Akanbi was an influential figure whose impact on the legal field and judiciary is undeniable. And as such, this paper pays tribute to his lordship's esteemed contribution, his unwavering commitment to justice and the rule of law has left an indelible mark on our legal landscape. His profound insights into the complexities of knowledge of justice not only advanced legal thought, but also inspired countless individuals to pursue equity and fairness in the legal system. As we reflect on his legacy, we are reminded of the essential role that dedicated jurists play in upholding the ideals of justice to serve the public good. I divided the paper into about 5 subsections. 1, we need to understand the digital divide, and we need to see the gap in the digital divide. Thereafter, we need to see what is the impediment of this divide to access to justice. Thereafter, we will examine the problem of access to justice. Why is it that when you have a case, particularly in this era of front-loading, I find it irritating. And lawyers here can testify, I find it irritating. I remember when the Child Service Commission of Oyo State asked me, looking at my CV, and they asked me, please, what are you coming to do in the judiciary? And I told them I am coming to make impact, positive impact. There are a lot of things I've seen going wrong. We can't continue to pay lip service to some of these things. When you have opportunity of being there, please be the change that we need. Please be that change. So we need to see access to justice. the problems. Why should it matter? Particularly in this era, why should a civil matter be before a judge for 7 years undecided? Tell me the kind of society, tell me the kind of individuals, tell me the type of foreign investors that we have trust and confidence in that kind of system. Now we look at some of these problems, what is causing the delay, and host of others. When we look at them, let us see the interventions of artificial intelligence, how artificial intelligence can obviate some of these problems. Thereafter, we'll go to suggestions and I will conclude, we'll round up. All this, I promise you, I will do it within a short period of time. Now, let us look at why we need to understand the digital divide. When we're talking about exploration, the evolution of navigation reflects humanity's quest for exploration and our ability to adapt to new technologies, shaping how we travel and connect with the world around us. The history of navigation is a fascinating journey that spans thousands of years, evolving from simple methods of sophisticated technologies. Some key milestones are the ancient navigation, the age of exploration, as in the 15th and the 16th century, where European explorers like Christopher Columbus and Vasco da Gama, they relied on compasses, on maps and stars to navigate uncharted waters. I remember the era of sextants, chronometers, up to now that we are in modern navigation. For some of us that are above 50, I remember when I used to follow my dad to the farm, particularly during rainy season. Sometimes we will be on the farm, say around 2 o'clock, no sun. That time, the only thing that we have, the only instrument that we read down that we have is the wall that is at home. That one that used to have one big pendulum like this. So my dad will look at his shadow and will tell us, this is time for sorrow. That used to surprise me. How did this man know? If we are there to ask you period, he will tell you, ask you to do, this is the time. The technology they have there was what he was using. Now, where can you be now that you will not put Qibla finder and straight away your Qibla will quickly be pointed out? That is the work of technology. Today, navigation is largely digital, with smartphones and apps providing real-time direction and traffic updates, making navigation more accessible than ever. The expression digital divide implies the gap between the individuals who have affordable access and skills to modern information and communication technology, which support them to effectively engage online, and those who do not. A lot of people, they have access to internet connectivity. We have a large number of people that do not have. Definitely there is a divide. Definitely there is imbalance. Available statistics put it that UNICEF confirms that about 1.3 billion children between the ages of 3 and 17 do not have access to the internet at home. According to UNESCO, approximately 45.2% of the world's households do not have access to internet. As of January 2023, a statistical study revealed that about 38% of Nigeria's population has access to the internet, compared to that of the United Kingdom, where 93% of the population has internet access. Let's consider it from gender perspective. Another recent report has it that only 40% of women against 62% of men are aware of mobile internet, thereby precluding internet use for over half of the population. Even for lawyers and legal profession, digital divide constitutes a significant challenge which may engender unequal access to legal information and services. According to the National Bureau of Statistics Telecoms Data Report, for the first quarter of 2024, internet user penetration stands at 42.65%. Nevertheless, this statistical data indicate that the digital divide hinders many Nigerians from accessing relevant information that can particularly assist in access to justice. Therefore, navigating this digital divide entails how do we address these disparities in access to legal resources and information that technology can provide, particularly artificial intelligence as a tool. Now there is a divide. Now there is disparity. That's divide. That's digital divide, and its impediment to access to justice. The essence of justice to humanity entails the pursuit of fairness, equality, and moral rightness in society. Justice serves to uphold individual rights, ensure accountability, and maintain social order. It embodies the data that everyone deserves to be treated with dignity and respect, regardless of their background or circumstances. Let me pause here a bit. I have some colleagues that where they post them to a judicial division, I had left discussing that the cases there, they are useless cases. And one day, I again and I asked, but not if I might ask, which case is a useless case? We are saying the kind of chieftaincy that these people are fighting over does not have meaning. It has meaning to them. They are grieved, and they believe the only area where they can go to ventilate their grievance is in the court. Whenever they come, the door must be open to them, and we must give them access to come and ventilate their grievances in court. From the Holy Scriptures, it is on record that Quran emphasizes justice as a sacred duty, and the Almighty Allah commands believers to uphold and stand firm for it. Even in the Holy Bible, it makes justice as a major theme by emphasizing establishing right relationship with others and having unbiased relationship with the truth. In essence, the conceptual connotation of justice evokes the protection of the weak and the promotion of the common good in order to contribute to a more harmonious and equitable society. Ultimately, without justice, the fundamental principles of fairness, the fundamental principle of equality that hold society together will be eroded, and it will result in chaos and anarchy, as people may resort to protest and violence to seek redress for their grievances. The essential nature of justice to humanity makes the Constitution to protect it by setting an affirmative framework necessary to giving practical content to its access. Besides, the Constitution giving us the framework, there must be substantive and procedural mechanisms existing in our society designed to ensure that citizens have the opportunity to seek redress for the violation of their legal rights within the Nigerian legal system. Access to justice is a fundamental principle of law which ensures that individuals have the ability to seek legal remedies and have their cases heard in a fair and impartial manner without undue delay. In the perspective of OECD, as Organization for Economic Cooperation and Development, access to justice refers to the ability of the people, the ability of business, the ability of communities to prevent conflicts and obtain effective, fair, equitable, and timely resolution of their legal and justice-related needs. Although the rule of law requires impartial and non-discriminatory justice, it also obligates legal empowerment, which enables meaningful participation in the justice system and builds people's capacity to understand and use the law. Little wonder then, the Constitution of the Federal Republic of Nigeria 1999, obliging citizens and unfettered access to justice. Whenever you have any of your rights being violated, the Constitution gives you opportunity of approaching a court of law, where to ensure that all the people, regardless of their background and their personal circumstances, can protect their rights, they can seek legal help, they can receive fair treatment under the law in order to close the gap in the accessibility, to close the gap in the effectiveness, and to close the gap in the efficiency of justice. But as important as justice is to human existence, a recent impact report on rule of law and anti-corruption in Nigeria confirmed that justice is not accessible to many Nigerians, many citizens in Nigeria, and this limits their capacity to challenge crimes, it limits their capacity to challenge abuses, and to challenge rights violations. The report further established that a significant gap exists between the justice need of citizens and the services available to meet those needs. If I may ask, let me pause here and ask a question. Can there be justice where there is no court established to entertain the subject matter of disputes between litigants? That's the first question. Could there be justice where available courts are not properly constituted with experts in the particular aspect of law applicable to the dispute between litigants? Let me share my experience and the kind of questions I used to put to my students while in the academic. If, as an indigenous of Oyo State, I wake up one day and I have a group, we go to have an assembly with the executive to demand for establishment of Sharia court of appeal in Oyo State. I said, what will happen? The following day I will make headlines. I will definitely make headlines. One fundamentalist, one so. And the issue of access to justice is beyond that. As we will see now, majority of cases, I have listened, majority of cases, I can say 90% of cases, coming for determination and adjudication before Macro Customary Court, they bother on issues of Islamic personal law, and it is Customary Court that is deciding them. While I was in practice, there was a day I appeared before my Lord Honorable Justice Ilorin, now DCA, in Shaki Judicial Division. And there was this dispute where two sections of Muslim community were fighting over who becomes an imam. And I asked this question, does this court have jurisdiction? And this is a grievance. People are fighting over this. There must be an impartial panel that will decide their grievance. And there is no such court available in Oyo State. Where should they go to? Number two, assuming a high court with its unlimited jurisdiction cannot close its eyes, cannot close its doors to anybody that wants to access it for justice. If a matter should come before me that borders on Islamic personal law, even though I am a Muslim, I don't have knowledge of Islamic personal law, that is enough for me to adjudicate on that matter. Will I not just jeopardize our jurisprudence in that aspect? Those are the questions we're supposed to ask ourselves. Can there be access to justice? There are a lot of other areas. I just digress into those. Let me give you another thing. That same case that came up before Justice Ilorin, I remember my Lord now said, please, you people should go and settle at home. I stood up there and I said, it was from my local government. We will see to how this matter settled amicably. In the course of our intervention, I now stumbled on a criminal case out of the same fact. They have committed crime, they've been reported to police, the police have pressed charges against them, and they've been arraigned before Ojo-Owode Chief Magistrate Court. And her worship there was honest and sincere to them. I'm a member of the team. If the two of you, imams, you can settle yourself, one of you will go to jail. If tomorrow, if you like, go to social media and say one redeemed pastor has sent an imam to prison. Can you see that kind of thing? Ladies and gentlemen, in the southwestern Nigeria, the Muslims have a sizable population, but Islamic law applicable to some of their affairs seem to be disfavored in that region. This is not issue of sentiment. Some scholars hold the view that Islamic law is territorially limited to the northern part of the country, and to that extent, it is not applicable to the southern part of Nigeria. I remember in the course of this work, I stumbled on the work of one of my colleagues, Professor Abdulkarim Olapoye of LASU, and he has this to say. Several judicial authorities have also held that the regular civil court lacks the jurisdiction to entertain disputes bordering on Islamic personal law. The danger, according to him, in this line of thought is revealed in the case of Afini and the president and members of Grade B Customary Court, where a Lagos High Court held that the customary court cannot dissolve a marriage conducted under Islamic law. The practical implication, therefore, is that litigants who are subject to Islamic law in Southwest Nigeria and other southern states are potentially denied access to justice because of the absence of Islamic courts in the region, and on the assumption that the civil court cannot apply Islamic law. End of quote. Most recently, on 8th day of April 2024, I think we have another one in this December, the Oyo State Customary Court of Appeal, Party Abdulkarim PCA, held in a similar case that Grade A Customary Court have no jurisdiction to entertain cases concerning Islamic personal law, and that the fact that there is no court properly and validly vested with jurisdiction over a subject matter is no reason to bring that subject matter to a court not validly vested with jurisdiction to entertain that subject matter. Then where they go to. But the dilemma is, since customary court lacks jurisdiction and high courts cannot adjudicate on matters of Islamic personal law, which court can the Muslim litigant go for issues involving Islamic personal law, particularly in the whole of southern Nigeria, where there is no single Sharia court, and that is the implication of, and what is the implication of that to society? The implication is simple. It's very, very simple. Lawyers from the judicial division where I sit can attest to the fact that there is no single day I don't take their first case. And this for these quarters, NJC say we should be repeating 6 in a quarter. And I think I have close to 20 now. We are coming to that. Due to the assistance of technology. Out of that 20, I can tell you 15 of them, they are on divorce, dissolution of marriage. Marriages contracted under the Act, the one we call statutory marriage. Now, if we have that one coming at a time, Mr. Jais here and some others, I ask questions. Do we have clergymen among lawyers? What do we do to enlighten people to make sure we reduce this thing to the barest minimum? And when you look at those cases that I pointed out, about 90% of them, they are marriages that are not up to 10 years. 10 years. 5 years. 2017, 2019, 2020, they are in court. In fact, some will come for leave because we cannot wait for 2 years. Might well give us leave so that as soon as possible we come for this solution because I did my piece. Now, if that happens to a marriage contracted under statute, tell me the one contracted under Islamic law, where divorce is simpler than what you can have under what do we call statutory marriage. And that is why we have a lot of people outside there. Today they are married, tomorrow they are outside married. What law determines the inheritance? What law determines succession? Because these people are people that profess faith different from the one that I court can entertain. And that is the kind of thing that we are talking about. Be that as it may, I agree with the public commentator that those cases expose the weakness in the judicial system and access to justice in the southern Nigeria. Be that as it may, we have seen the gap now, the digital divide. We have seen that gap again in access to justice. That has the greatest implications for weak citizens. The significance of all the above earlier quoted statistical data is that there is a wide gap between those who have easy access to digital technology and the internet and those who do not, and that the difference significantly impedes access to justice. As many legal resources and services are increasingly moving online, so much so that individuals without reliable internet access or digital literacy may struggle to obtain legal information, may struggle to file documents, may struggle to connect with legal professionals. These create barriers for marginalized communities, exacerbating existing inequalities in the justice system, and this situation called for need to do something cutting edge. It calls for something transformational. It calls for something that will improve delivery of justice, both in terms of quality and scale, particularly in this information age, in which knowledge and information are increasing exponentially. Let's see the problem of access to justice. Before exploring the intervention of artificial intelligence, let us reflect on what either don't characterize access to justice. Within the Nigerian legal environment, it's imperative to state that, before I go in, let me pause a bit. I used to ask my students, I used to charge their head sometimes. I used to put these questions across to them. Can Nigeria be great? Can this country be great? After lengthy argument, some of them will agree with me, some of them will disagree with me. Even undergraduate and postgraduate students. Some of them will disagree with me. Because for you to have a great nation, you need a stable, very stable government. And that government will bring about a way of managing conflicts, a way of managing law and order, a way of encouraging civil administration. If that is not in existence, there is a problem. If it is in existence and it is not well articulated or explored, there is equally a problem. Let's look at what we have today. Can Nigeria be great? I put that question to all of us. But my own answer is that Nigeria cannot be a great nation. If you allow me, allow me. And that is why I appeal, ladies and gentlemen. That's why I appeal to gentlemen of the press that whatever I say here, please don't take them out of context. Let me conclude that statement before you agree with me or you disagree with me. Nigeria cannot be a great nation if the individual citizens and governmental institutions stick to obsolete strategies that can no longer impart progress in its administration justice system. We need to change. Ladies and gentlemen, I have noticed one thing about change. I ask myself this question: what is wrong with our civil procedure rules? Are there no enough provisions there that can accelerate the cause of justice? Okay, recently, from the old criminal procedure rule, we moved to administration of criminal justice law, act and to states. These are procedural laws. What's wrong with them? Why do we still have criminal cases staying like 1 year, 2 years before they are determined? We like paying lip service. We want this change, we want this change. You will never see the kind of debate across the media when this thing was to come into operation. Now it has come since 2015 or 2014 till date. And what has happened? Has anything changed? I have civil cases that I have 6 volumes of a file for 7 years when we have not left the trial stage. 7 years. And when I ask how many witnesses do you want to call? The claimant will say I have 2 witnesses. The defendant will say I have 1. This one will say I have 1. I say all in all 5 witnesses. And it's taking 7 years. Is something not wrong with our psyche? Something is wrong. We don't like and we have to delete the junks on our brain for new ideas to come in. Yes, let me tell you, if you carry a lot of things you carry from academics, my Lord Honorable Justice Evan Fabraham, and you go to the bench and you want to implement it now, you will face discouragement from members of the bench first. Election petition. You have a file where a party wants to call over 200 witnesses and to tender about 500 documents, and you give me within 180 days, I must do justice. If I don't leverage on technology, tell me, how will I do that? And we are recording in manual. And that's why on a daily basis you see judges falling down and dying. A lot of people will see the glamour. Oh, they've increased their salary. They've increased it, they've increased that. Please go there for 1 month. You want to come out next month. I'm telling you. We will see now. By the time I'm running it out, the statistics, from my own judicial division, from my jurisdiction, which I believe is what is applicable in others, in Kwara too, you will see that we have a lot to do. The members, the bar, the bench, and all other stakeholders in the administration of justice. Now, year in, year out, successive governments in Nigeria keep exerting efforts at winning foreign investors, but our individual and institutional attitudes are sending wrong signals capable of discouraging influx of foreign investors that can boost our economy. Do you need to woo them? Do you need to woo them? I remember we were taught, do I need to put a big signboard? This is Ayola Adaye and Co. I have never seen it in front of your office. Before I know that office, I was looking each time I pass. It is what you do that will advertise you and that will bring people to come to you. That is the way it is done. So do we need to go cap in hand? Please come and invest in Nigeria. They will look at a lot of things. If I commit and sink my investment into this jurisdiction, what is going to be the likely outcome? Dispute resolutions and access to justice, they are key factors that a businessman may likely to consider before sinking his investment in jurisdiction. No investor will like to establish business in a country where his pre-business survey reveals that the justice mechanism in his target jurisdictions are unnecessarily and irritatingly delayed and complex, where the environment does not enable access to legal information and resources which may enlighten and animate residents about their legal rights, or where insecurity is the norm rather than an exception. In summary, some of the problems of access to justice are this: lack of funds is one. Some litigants cannot afford the logistic cost of access to justice, such as lawyers' fees. Several instances, you will see litigants come before you. You will see this financial imbalance. This one has the financial wherewithal to pursue his case. This one does not. And it will definitely affect that case. Not in the aspect of corrupting the injuries, but in the aspect of hiring a good lawyer who will do a good job for you. So lack of fund is one. Ignorance of litigants is another one. Some litigants do not know that time run against them. Statute of limitation. They will go home, they will sleep there. It is when they decide, oh, we have gathered enough money now, want to go to court, they discover that, oh, at the registry, the matter is there. They are bringing it to court, like I used to say, for a decent area. There is delay in disposal of cases. That is where we have problems. That's where we have, and what is causing it? A lot of things. One of it is congestion of our courts. From my own state, I say it. There is no single judge that has less than 1,000 cases in his docket. There is no single judge. All these things will be done manually. It is not as if the judiciary will give you laptop to operate. Without one, I look at it. If I have 1,000 cases before me in my docket, each quarter of the year, I must give 6 judgments before NGC will know that I am performing. Now, in this era of technology, the way I was taught before I left academics is that if your next promotion, you are to present 5 papers. My professor told me, prepare yourself for 10 papers. Because when the nature of this country, when you get to where the meeting, the promotion meeting, appointment and promotion committee, your enemy may be there. You say, no, this paper will not go. If they hate you, before they remove 5, you will get to the 5 they need and you will skate through. And that is the same thing I take into judiciary. If NJC say we should present 6, at least I am tired of this quarter that I cannot present at all. I will present 8 or 10. Now, but we are having one problem with NJC. What is the quality of the judgment that we are submitting? Is it quality that NJC needs or quantity? When some of these judgments are not weighted, they are supposed to be weights attached to each of these cases. I have a criminal matter that have taken 17 witnesses of the prosecution before we move to that of defense. And the last time, my now learned brother, only the scholar of show was for the defender before he left. Before he left, that was the last appearance. So I said, how many witnesses did you call? He said, my Lord, we are calling 50. And you see, why would there not be conjunction in our court? But if we leverage technology, these problems will be reduced. That is the angle I am going. What about attitude of counsel? I am sorry, I practiced for, I think, 20 years and above before I joined the bench. 20 years. And to the glory of God, I appeared before all sorts of courts, including Supreme Court, before I joined the judiciary. Now that I am on the other side now, I am seeing lawyers different from what I used to see when I was. And then I asked myself this question. Maybe I was behaving while I was there. Attitude of counsel. There are a lot of things there. And the Constitution says you must give them access to justice and fair hearing. Apart from that, we have disposition of judges and lack of digital skills. That's another problem. Of recent, I was at the conference of NJC, and a learned brother from another state asked, if you want us to align with this technology you are talking about, NJC, please make sure you deploy people that will come and teach us how to use computer, laptop. So that you, at this age, and one person gave the good answer. Said, do you have a grandchild? That will teach you. At the time that I appeared before one international organization that came to interview us for the position that my brother mentioned, Director General of CITN, I remember that auditing firm asked me a question. Please, may we know, can you tell us in percentage your knowledge of computer, your computer literacy? So I looked, because I was coming from academics, I looked like this. I said, 65. They said, wow, this is the person we are looking for. 65%? Said, good. It means you know more than those that constructed this computer. Because they said they did not on their own understand 5% of what they did. You will discover some of these things, the way you interact and intimate yourself. You can't distance yourself from technology, and you want technology to assist you in the delivery of justice. So that lack of digital skill, some courts are ill-equipped. Lack of provision for factual hearing, that's another. Our own civil procedure rules now ask factual something. How can somebody want to testify in a diverse matter where the husband wants to come and testify, the wife will testify, two witnesses, and they close their case, and he has to travel all the way from Germany to all the way from Germany. I think I have stopped that in my court, and it will never come up again. What I do is factual hearing. Factual hearing. This year alone, I can say that I have taken more than 10 from UK, from Germany. If we are entertaining fear of having interaction with this technology, we will not understand the challenges there, and we will not know how to fix them. Go into it first. Sometimes if you have a witness, you will want to affirm or you want to swear. Do you have a Quran there? Whatever you post, the other side there, do you know whether it's Quran or ordinary book? You don't know. These are some of the challenges. But with time, we can overcome. Somebody may have a document and may be reading from that document. Put it here and be reading and be looking. So sometimes when they are testifying factually, they will say, please look at me. Look at me. At least we have conducted exams like that when I was at CITA, and we have a way of knowing when somebody was cheating, even factually. So these are some of the things that we need, and before you know it, our access to justice and justice delivery system will definitely improve. Intimidation. The orientation and interest of litigants in this country when lawsuits are instituted is despicable. They take legal proceedings like a war that must be waged and must be won desperately. Desperately, including doing unethical things. There are witnesses coming to court to come and testify. What is the intervention of artificial intelligence to some of these problems? The history of artificial intelligence reflects a journey of innovation, setbacks, and breakthroughs, shaping the technology we experience today. Its origin is quite fascinating and dates back to the ancient times, but it really began to take shape in the 20th century. The idea of intelligent machines had existed for centuries, with myths and stories about automatons and artificial beings. Philosophers like Aristotle laid the groundwork for logic and reasoning, which are fundamental to artificial intelligence. The formal founding of artificial intelligence as a field occurred in 1956 at the Denver Conference, where researchers gathered to discuss the potential of machines to stimulate human intelligence. History had it that John McAfee, an American computer scientist, coined the term artificial intelligence and was widely recognized as the innovator of AI due to his outstanding contribution. It evolved and developed over the years and became more integrated into everyday life, with applications in virtual assistance, search engines, recommendation systems, autonomous vehicles. Most recently, there comes into existence what we call robot citizen, created with a realistic human appearance and the ability to see and replicate emotions, as well as other AI tools and software applications that the use of algorithms to perform specific tasks, solve problems, stimulate economic growth, and increase productivity. I remember when NPA Okomosho, I think last year, Bawi, my sister, Professor Amaloy came to present the paper on this. And I remember I made a comment that because I just returned from a conference in Canada. That day, the presenter came and said, even your judgment, AI can write perfect judgment for you. I said, hey, this my work is now made simple. Then I come back home, I put all the facts, all the testimony of business and everything. And I was waiting for AI to write a judgment for me. I did not say anything. So rather than having a misconception about what AI can do, it is a tool that can assist you in legal research that will make your work faster and will improve the quality. But it is not that human effort at all will not be there. We shouldn't go with that kind of mindset. Some of the problems of access to justice highlighted. Although the concept of AI has been around for a significant period, its utilization in the legal field has been recent advancement. Initially, AI adoption in the legal field was limited to the largest law firms handling significant cases and deals. However, over time, the applications, the developers, and the users of AI in the legal operations in the legal field have expanded so much so that AI is now being employed in various legal tasks, such as legal research, predictive analytics, factual assistance, document automation, and compliance support. Some of the problems of access to justice earlier highlighted constitute serious conundrums that hinder societal progress and smear the image of our nation globally and can upgrade. And the deployment of AI tools and constant interaction and familiarizations with them can update and clear those impediments. In essence, artificial intelligence can significantly enhance access to justice in several ways, which are these. I will quickly take those. One of it is enhancing legal research. The technological development in AI promise to destroy the very foundation of how legal work is practiced and delivered. The shift towards AI enhanced practice of law is significantly changing the role of lawyers and the structure of legal organizations. One crucial area where AI-powered tools are revolutionizing the delivery of legal services is research. According to PowerPoint, enhanced application will be able to conduct legal research intelligently, eliminating the need for lawyers and law librarians to engage in research activities themselves. This development can allow lawyers to focus more on analyzing information instead of spending countless hours searching for it manually. Let me state that on any discourse about access to justice, government and policymakers, judges and courts, lawyers and legal professionals, legal aid organizations, community organizations, academics and researchers, and the public are all concerned stakeholders that have important roles to play, ranging from making law and policies, interpreting laws and accessibility to court, advocating for litigants, provision of free or low-cost legal services to people, educating and enlightening the people, studying access to justice, issues to provide insight that can inform policy and practice as well as constant feedback for access to justice. For these stakeholders to impact our legal system positively within their respective space, legal research is foundational to improving access to justice by empowering legal professionals, educating the public, identifying systemic barriers, supporting pro bono initiatives, and ultimately contribute to a more equitable legal system. Technology generally offers judges, lawyers, and law firms the opportunity to improve their overall efficiency and to adapt to a progressively agile working environment. As a matter of fact, conducting online legal research, solving the growing number of websites has become more and more a part of judges' daily activities. Therefore, the use of search engines and text mining techniques can greatly increase both the quality and efficiency of legal research. In other words, artificial intelligence particularly can help legal professionals to quickly analyze bulky legal documents, case laws and statutes in order to speed up research process and ease lawyers and judges search for relevant information. AI tools such as raw intelligence can enhance the efficiency of legal research. AI will also help in optimizing court administration. Court administration plays a crucial role in ensuring that the judicial system functions smoothly and fairly. It encompasses a range of responsibilities such as case management, scheduling, and public access to court services. Intelligent algorithms can automatically schedule court dates and times, thereby getting through hearings, trials, and other legal proceedings properly coordinated to minimize delay and optimize the use of court time. It also facilitates case tracking by providing updates on status changes, upcoming hearings, necessary actions for informed parties. This helps to keep everyone on the same page and reduces the likelihood of missed deadlines. To reduce overwhelming backlog of cases, AI tool known as Relax, used in the European Union, can be adopted to automate case management and reduces administrative delays in Nigeria. Experience has shown that in an election petition, where hearing and delivery of judgment is restricted to a specific timeline, both lawyers and judges may have bulky processes and documents to contend with. For instance, a party may list over 200 witnesses to court, improving its case, have more than 500 documents to tender, and the court proceedings are taken manually. By leveraging AI tools, efficiency and effectiveness in managing public court documents may be enhanced, and this will ultimately save time and resources for legal practitioners and thereby improving overall legal processes. We have personalized legal services. Nowadays, you see the knowledge of people about legal terms and terminology is increasing. And that's why on a daily basis, ask even ordinary Nigeria going on the street now. The moment he knows how to use this smartphone, he will tell you what defamation, criminal defamation and civil defamation is. He will tell you now. Because of what? The moment they have this issue, pop it up, they will quickly go, what's the defamation of the thing they are talking about? All this kind of personalized knowledge, without coming to a lawyer for consultancy again, you will see them knowingly. And that's why you see some of litigants, they are more lawyers than the lawyers themselves. They will tell you, Oga, and if you take me what, you can find this motion to fight that and it will work. Because some of them have accessed AI and they know some of this. This improvement facilitates access to justice by enabling individuals from underprivileged backgrounds who would otherwise not afford traditional methods access top quality service at affordable rate, which ultimately increases efficiency. The next is predictive analytics. It entails the use of statistical techniques, machine learning, data mining to analyze historical data, make predictions about future events or trends. It involves identifying patterns and relationships within the data to forecast outcomes, allowing organizations to make informed decisions based on insight. Essentially, it's about using data, past data to anticipate what might happen in the future. When you interrogate, when you integrate AI into this, you will be able to predict the outcome of your cases. Let me point out this. There is one phraseology that negatively impacts access to justice. It is likelihood of bias. Likelihood of bias when you want to invoke the supervisory jurisdiction of the high court. You want high court to supervise the proceedings of inferior courts. One of the grounds is you prove likelihood of bias. It's used to occur in legal and quasi-legal proceedings when there is probability that certain prejudices and stereotypes can influence decisions and actions in a particular way. It manifests in situations where there is personal animosity or hostility. You may have that for a lawyer. Please don't forget, judges are human beings. They are human beings. When they say we should exercise our discretion, And the discretion that I exercise, that of my Lord, Honorable Justice Plaza, cannot be changed from my own. That part, because the law cannot capture all the things, law cannot envisage everything that will happen. Therefore, there will be instances where judges will have power to exercise discretion. So you have personal animosity for somebody who is appearing before you. I'm not saying judges you to use that, but literature says it is a way of having likelihood of bias. Apart from that, what about personal association and friendship? I have a colleague at Osun State that told me his practical experience. That Odua University, the Faculty of Law there organized a program. They invited the CJ of Osun State. The CJ could not go, and he said the CJ asked him to go and represent her. When she got there, after there was time for photograph, and she took photograph next to that man, that the owner of the university. At a time that that man has a challenge, he's been arraigned for criminal act, the case was assigned to that person. Instantly, he said he went to CJ and said, "My Lord, I decline taking this case." Should he take that case that day? The following morning, you think you are the only one that had that picture? Social media will be awash. See the judge with this man, and they will be saying a lot of things. And that's why you see, coming into this side of this work, it has taken away a lot of things. The way you are saying, my Lord Justice, before, it may not be like that now. The Asalatu she's attending may not be like that now. You may not know. Some of these people are fraternizing you, so that when there is time for you to pay them back, they will tell you, I think you have forgotten. An issue of justice is more than that. The question I used to ask myself is this: one day, Honorable Justice will stand before another judge that will ask me, how did you? So what will I say? Will you be there? It might be in my grave. It may be on day of judgment. What will I tell God? Because of that, no influence, no matter how highly placed. And that is it. There is a sharing. The fact that you have just one bad egg does not mean that all of us are bad. It does not. I used to ask people, are you saying I don't have my name and integrity protected before I came here? You think it is a day work before somebody will rise from scratch to associate professor or the professor of law? We have, even in this new appointment, we have them in Ohio State. As far as my own state is concerned, appointment is on merit. I don't know anybody before I got my own appointment. I can say it anywhere. I was coming from class to class. I did not. I was coming from class. I used to take accounting, business law, and company law. I think I was taking them company law now. And I was coming from class. I have seen some of my students here. From tourism center. And the phone enter. I don't usually pick a number. I don't know that day I picked. This is Dr. Adedokun from Social. I say yes. And I remember before that time, I discussed with my boss, President Makabi. Okay? This one that we have some people on the list dying. My name is there, but I can't tell anybody. My name was on that list as substitute, but I cannot tell anybody. Okay, I said, hey, please keep on praying. Keep on praying. Keep on praying. And we kept on praying. Coming from that class, my phone ran, and the Ariku, Dr. Adedokun from Kwata said, yes, may I know he's speaking, just to mention his name. So we want to ask you, in fear of what happened, we are moving your name from substitute list to the main list. Do you have any objection to it? I said, I don't have. Who called me? I don't know. The same time, from the same class, the following Thursday, as I was coming out, I received another call again. You have a letter from NDC for interview. Then I look myself, oh my God, will this thing happen? It was when it happened. I did not know. Professor Dr. Salam is here. Thank you very much. I did not know how people went on that ground to find out who is this type of person, even here. I did not know. I just heard from my secretary school and primary school, they came to look after your doctor. I said, wow. I did not know. My mom called me. My mom is over 100 years. And she's alive, ill and dead. They called my mom. Are you the mother to those who say she was? Hope he did not do anything. They said, no. Are you at home? They went into my home. That's my humble beginning. To find out whether this man is worthy of being appointed in church. I'm the emotional type. I don't want to go to the side. It was after that I knew that the exam that we did, the interview that we conducted, you are number so, this is your something. This is your number. And that's why we thought, oh, what about that man from Kwasu? I did not love him. This last one, there was no lobby because I am already an insider and I know how it happens. You sit for exam. That you are CR does not mean automatically you will get it if you do not pass. That is the kind of thing. The only thing I will plead for in all our judiciaries to add into it is that in this era, digital literacy should be one of the things we will consider before happening. It will help all of us. Ladies and gentlemen, addressing these biases is crucial for improving access to justice. Utilizing tools like predictive analysis, it will enhance. Let's look at the challenges now. We want to use artificial intelligence to upgrade all the problems. What about infrastructural limitations? It's not everywhere. Many areas in Nigeria face inadequate internet connectivity, technological infrastructure, and this can hinder effective development and the use of AI tools. What about digital illiteracy? You can imagine a judge that is saying you should come and teach you how to operate laptop this era. Digital illiteracy. What do we do? That is the challenge. Data privacy and security is an important, even though we have Nigeria Data Protection Act in 2023, but it's still thread along a very serious controversy. The question is this: data privacy is still a human right? Data privacy is still a fundamental human right? They are two different things. A right is fundamental, is basic to you, to your existence. And that is why the Constitution is not the one that gives you those rights. The only thing that Constitution provides for is that those rights are protected and guaranteed. They were given to you by God. Rights to talk, that's freedom of speech. Rights to walk, that's freedom of movement. All these things are there. If you have a child and that child does not walk after 2 years, you feel worried. If that child does not talk after 3 years, you'll be worried. Because these rights are important to us, the Constitution says they are protected and guaranteed. What about data privacy? There are two schools of thought. One school of thought says no, it is not part of human right. Another school of thought said no, it is part of human right. But recently, Supreme Court has brought a respite on the issue of data protection in Nigeria. In incorporated trustees of digital rights lawyers initiative and others against National Identity Management Commission, the Court of Appeal has cleared the conflict occasioned by the decision of High Court on the status of data protection rights in Nigeria, when it held that right to privacy of citizens as guaranteed under Section 37 of the Constitution includes the right to protection of personal information and personal data protection. What about cultural and language barriers, particularly considering the heterogeneity nature of Nigeria? Cost implications. Developing and maintaining the IR system can be costly, and legal aid organizations may struggle to secure funding for such technologies. limiting their availability to those who need them most. There is no clear-cut regulatory framework that will govern the use of AI within the legal sector, and this can lead to uncertainties about accountability and the ethical use of AI technologies. Ladies and gentlemen, addressing the above challenge is essential for ensuring that AI can effectively enhance access to justice in Nigeria. As a matter of fact, legal organizations can invest in infrastructure by collaborating with government and private sectors to improve internet connectivity in underserved areas, enhance digital literacy, implement strong data protection policies, develop multilingual AI solutions, seek funding and partnership, and engage with policymakers to advocate for a clear regulatory framework. By taking these steps, the potential of AI to improve access to justice in Nigeria can be enhanced, and the Nigerian legal system may be more inclusive and effective for all citizens. Thank you.
May I request that all students of law, University of Ilorin, should be on their feet while applauding my Lord for the beautiful presentation.
Thank you. Thank you very much. We thank the Lord Honorable Justice Dr. Karim Adedeku for that elaborate, thoughtful and insightful lecture that he just delivered. We appreciate your Lordship's wisdom. So, as a mark of appreciation, as well as a mark of honor for one of us who was once a law student like us, who at one time also wore the regulatory or the regulatory dress of black and white in this faculty, and has risen through the thick and thin on the legal profession to reach the level he is today, and we hope and we pray that he continues to rise. So as a mark of appreciation and in recognition of his service to the faculty as an alumnus of the faculty, we hereby invite to the podium Honorable Justice Suleiman Akabi to present the faculty's plaque of award of recognition to Honorable Justice Akabi.
Mr. Chairman, because we have no ladies in the legal profession, Honorable Justice F.F. Abdulrazak, principals officers of this faculty, particularly the Dean of the Faculty of Law, University of Ilorin, members of the Ogbomoso Bar Association. I need to recognize them especially because they were here in numbers. And then members of our own. I don't want to say much because he has done what Napoleon has not done. There is this old saying that says the taste of the pudding is in the heat. And if I also have to go by the musical history of Mali, quoting from El Selassie, he says, who the calf fits, let him wear it. You could see he has made not only the judiciary proud, he also has made the academic proud, and then the legal profession. He's a member of the bar when he was a lawyer. He was a member of the bar. He was in academia for several years, and then we have snatched him to the bench to join us. And you know, he's also an alumnus of my own institution, Ahmadu Bello University. So I don't want to say much. I want to, on behalf of the University of Law, Faculty of Law, in conjunction with the Honorable Mustafa Kandid Foundation on the public relations, present to you this very beautiful congratulations.
Sorry, before you step back. Well, the faculty also recognizing your contribution to the academic profession, particularly the faculty as an academic institution, also wishes to present some souvenirs to the faculty to you, sir. And it will be done by the chairperson of today's occasion, Honorable Justice F.F. Abdulrazak, our teacher, our mentor.
Once again, ladies and gentlemen, yes, I want to appreciate the guest lecturer. It has been a very, very educative lecture. I really enjoyed it. He has opened our ears and eyes. And once again, please don't put him on the face of the paper. I don't say he said Nigeria will not be great. He said Nigeria will not be great because we don't have the infrastructure to make the air facility work very well. That is it. Please, so on behalf of the Faculty of Law, I want to present this books. Number one is the compendium of the cabinet of the report. Another lecture series. This one is another lecture of women and gender justice. Another lecture to you is one of our law journals. I'm still part of the University of Ilorin. It's one of our law journals here. Against that, against what this is I say. Another book by this report is Balance of Government. Yes, you are one of the editors here. Another one by our Oga, Ekwole, and Kaki, honor of Professor Abdulkadir Zubair. As a scholar, as a jurist, as a law teacher, we are part of that. So once again, present this now.
Thank you so much, my lord. Before moving on to the next item on the agenda, I would like to recognize the presence of the Dean of Physical Science, Professor Alakara. You are welcome, sir. Representing the Dean of Law and Muhammad. You are welcome, ma'am. I also like to may I invite Dr. Hafida Muhammad to please kindly join my notes on the item. Thank you very much. May I also recognize the presence of my own chairman, the chairman of the MBA Ilorin branch, Mr. SMH Koshemani. You are welcome, sir. Accompanying him is the vice chairman of the branch, Mr. Sunday Eke. You are welcome, sir. I also like to recognize the presence of the chairman of the Kwara State Electoral Commission, Mr. Okola Tukuru. You are welcome, sir. OIC KW1 is blocking a vehicle. It's a black SUV. It's blocking a vehicle outside, please. Thank you.
Particularly the area that has to do with divorce. I won't go into this other area that Oyo has not been able to probably get a Sharia court or something like that. This is a public lecture. For this area of divorce, for judges, I think we must be very careful when we are entertaining divorce matters. Particularly the area that has to do with connivance and conduct. You know, lawyers, as apology to most of them, are very clever. The bar makes the bench also makes the bar. You know, when you are entertaining divorce matter, and you find out that the divorce will be pronounced upon within short time, you need to be very, very careful. Particularly where some of them come from overseas. There is a situation where you have, excuse me to say, not all of us, there are people with integrity among them. They connive or condone with some of the listeners, all in a bid to get visa overseas. So you have to be very, very careful granting divorce, particularly within short time, within the area of 2 years or 3 years. There has to be a kind of investigation. I experienced such in my court, and I was very careful. They will arrange the witness to come to court, and the party to come to court, and at the end of the day, you find out that it's not the real party. The issue is, sometimes judges also seek guidance before they come forward. They seek divine guidance. It was God's intervention that made me to adjust such matters. Because these people from overseas, they can come and find out whether there was any divorce resolution. So you need to be very, very careful when you are granting such divorce. At the end of the day, it becomes your own problem. You may not know that the divorce has not happened. You want to move from UK to America, and in the midst of this, within 2-3 years, you have not even exhausted the petition of the matrimonial postal section 15 specifically. You want divorce with the connivance of some of our, I don't want to call them sharp practice lawyers. There are those among them. Because we are talking now, students are here. We need to also guide them so that at the end of the day, they will not be carried away by some of these antics. Then another thing is this may not be unconnected with the topic. University of Ilorin may not be there. I don't know whether it's true. We have students here, the faculty of law students, great faculty students, coming up to take up leadership from all of us here. And one thing brought to my mind, I was discussing with my father here. We have several young cases from 18, 21, 23. Some of us entertaining some of these cases. We now wonder, even if it's America or Canadian or trying to defraud, is it not a woman being? Are you not bringing this nation to this purpose? So you now find these are people who want to take over leadership of us. Where do we go in this country? I think we are more with this digital technology than any other thing. I deliberately fight of the point. Thank you.
Questions?
My lords, the Senate president, I have to to me, it's a homecoming because I was one of the first set of Ilorin students, Muslims. I don't want to talk to my fellow students here. Now, brother, why the better of you are not taking notes? It's not too good. You have an institution. I didn't finish from Ilorin because of that problem with the NJ and the NJ House of Representatives. But the foundation of my practice was laid in Ilorin. My lord talked about it in land law. He laid a very solid foundation for us. And that is very, very whatever. So I don't encourage them. I don't want to go to jail. In the long run of history, the central and the people will always know. The best idea is when you listen to people in authority who speak to you and you take notes of what they are saying. It's going to be very useful to you. Let me talk generally about the issue of administration of justice and not address. My own view is that the day we learn to respect our laws and enforce the laws is when the ground begins. In the Electoral Act, we talked about electoral offenses. During the election period, we saw somebody who went as far as embarrassing the whole world when he was shouting, Jega, you are biased, Jega, did they come? In the last election too, when the result of the a group of people went to the National Convention Center and were disturbing the convention. Who constituted them? What is the outcome? It is when we decide that these laws must be enforced and people must be responsible for whatever they do that we can move forward. Because for any country to move forward, judiciary is the beacon to the world. Investors want to see how you enforce your laws. If they bring in their resources, will they be safe? These are some of the issues we are talking about. So except we decide that we are going to move forward to respect our own laws and enforce them, we are going to move. Thank you.
Thank you very much. Some questions from those listening. I want to see any thoughts.
Thank you, sir. The first question is, my name is Randy Fabiola from the former students at the Faculty of Law. Is AI replacing an equal student?
Good afternoon, my lords. My name is Ilorin, Oluwaseun titles, a 311 common law student. Yes, sir, you made mention as regards virtual sitting and how you took a testimony from someone at Germany. They went on to say that some of them can be so smart that they might not actually swear on the Bible or on the Quran, and there's no way. So I want to ask that what's the effect if later on evidence is adduced that we do not swear on the Quran or on the Bible?
The last question from there. Well, the guy in cap.
The guy in cap. Mom, the guy in cap. Hey. What's a couple of going on?
The court is not.
Good afternoon. Scan permission of companies. My name is Momi Abisoma. I'm a level student. I want to ask, during the course of the presentation of the course, I want to ask that you make mention of the cases that some certain subject matter that cannot be entertained and the Saudi contracted. Maybe there is a solution I want to look at between the parties. What's like the advice you want to give to the parties so that they can have the access to justice? Because the matter cannot be entertained and the salary here. What advice do you want to give to them so that they can have the access to justice based on the course? And I want to make comments on the presentation that the AI is not to replace the access to justice. What's called it just called to supplement the access to justice.
Go.
Thank you very much, the chairman. Mine is the question that has to do with access to court and access to justice. many have argued that access to court may not necessarily mean access to justice. And court is also the only tool, or the major tool, for access to justice in Nigeria. Now this AI we're talking about, is it actually promoting access to court alone, or is also promoting access to justice? So I'd like to hear your views on this particular. Thank you.
On the issue of whether the cases amicus curiae, I would say no. I would say no. There are a lot of things involved before you invite somebody as an amicus to court. Experience is there, knowledge is there, and so on and so forth. You can't just invite anybody to come and address you. Although when you use artificial intelligence, you can explore different areas of law, succession, on human rights, on will. There are times when you put some things across the way I advertise. At the end of the day, I will tell you, you need to study the legal system of that particular area before you do it. So who are those that can do that? You as a judge, AI will assist you. The articles that is coming to submit, AI will assist him or her, but it cannot replace completely to say that look, there won't be articles to read again, it is AI. No. And if anybody says that, as far as I'm concerned, I don't see it as replacing on the issue of some people swearing with Holy Bible or Quran, particularly those that testify abroad. I have not experienced a situation where somebody will come and say, not swear with this or that. I have not. And one thing that I noticed is, apart from your right of appeal, there are a lot of post-judgment things that we don't have remedy for in this country. Except when you are watching them on film. For instance, when a witness, an accused person is before you, and that person was sentenced and convicted, then by hanging, and while he was on the road waiting for the hangman to come, another person confessed that I was the one that did this. What is the effect of that on somebody that court has made pronouncement on? As a judge, do you have what it takes to say, oh, court should convene tomorrow, or you remove that man from there? No. Somebody must have brought an application before you. He will be arguing. A lawyer will come and tell you there's no provision for that under our law. But what is the essence of law that does not bring justice? And that man needs justice. So I have not experienced that kind of a thing. And in Nigeria, I have not seen it. Don't let me go further. I have not seen it. On the issue of cases, or advice to people in the southern part of Nigeria access to justice, I will advise them that they should pursue their rights politely and talk to government. One aspect of it that I do not say is this. We are denying ourselves a lot of things in the southern part of this country. For some of us may know, some may not know. I know the former Chief Justice of Nigeria, Honorable Justice Tanko, was a Qadi of Sharia Court of Appeal. And from there, to Court of Appeal, and from there to Supreme Court, and he became the Chief Justice of Nigeria. The Chief Justice. Some of our students, some of our children that are studying combined law, University of Ilorin, or in all other northern parts of the country, where they expect them to practice. There are three ways for northerners to rise to the top In some southern states, we have just one. Somebody from customary court of appeal can rise to court of appeal. Somebody from high court to court of appeal can rise to Supreme Court. Somebody from Sharia court of appeal can rise and get to Supreme Court. Here in the south, there is nothing like that. Where they have different access. A time will come, you know, Constitution stipulates certain number of people when you are elevating people to court of appeal. 3 of them must be learned in this, 3 must be learned in this. So that when there are issues that borders on either customary law or Islamic law, they will not panic. The judgments that emanated from Sharia court of appeal of recent, a lot of people will be confused. Why would an appeal from Sharia court of appeal in the law be decided in Kano Judicial Division of Court of Appeal? When they appeal to this case and you discover that there is no Sharia panel, and the Sharia panel is sitting in Kano, the president of Court of Appeal can say, take it to that panel and it will be out. So the time will come where you will be qualified to be elevated to Court of Appeal as a judge of the High Court, but there is no opening for you there. They need an expert in Islamic law. Who will fill those vacancies from the north? What happens to our own from the south? So unless we sit down, what we are saying is that it's not that we take away the one they gave to other members of other things. That's what we are saying. This is our own rights too. I constructed my marriage under Islamic law. I want that I go. He said you go to customary court. Okay, there are a lot of things that go along. Issue of inheritance, issue of succession. Where do we go? Okay, look at this again. I have instances where hijab sister brought another man, his husband, and their husband to court. 2 of them. You don't need anybody to tell you that this one and this one. And I asked them, what do you people to statutory marriage? I asked them in the court. Then there was this contention. The husband said, no, we did not do marriage under the act. When I have certificate before me, say what we did was Islamic marriage. A lot of us these days, we will do customary marriage. We will do nikah, Islamic marriage, and we will go to registry without asking for and without knowing the legal implication. Now the question is this: why do they go there? Some of them want to travel out, and the only way of authenticating that their husband and wife is to have the certificate. Sharia court of appeal too, and making appeal, have a place in your registry where all the certificate issued to the Muslim sisters and brothers that can be authenticated and verified, can be registered there. The embassies will recognize those certificates. We can't do it by what can we do? Muslims will sit down. Is that a court of law? No. So unless we have it in place, let me give another example. Recently in Lagos, the CJ of Lagos, Honorable Justice Marshal Aluga, created a section of customary courts to be listening to Islamic law matters. Those people may be learned in Islamic law, but the point is that's a customary court that constitutionally does not have jurisdiction to private. So where do we go? Unless we appeal to government, this is not an issue of fundamentalism. This is not an issue of somebody causing trouble. This is not an issue of somebody taking another person's right. Give us our own so that we will be able to use it to benefit us. And that is it. The only advice I can give. On the issue of AI, whether it promotes access to justice, in the course of writing this paper, I wanted to make a case in that aspect. Access to courts, access to justice. Because when I look at some of the authorities, particularly in Nigeria with law report, you will see access to court, access to court, access to court. What's the essence of having a court? Some will say it's a court of law, some will say it's a court of justice. I agree with you. You may go to court and you may not get justice. There are instances you will go to court, you will get judgment, but you won't get justice in those judgments. Look look at it, a matter that was pursued for say 7 years in the High Court, 5 years in the Court of Appeal, say another 5 years in the Supreme Court, say over 20 years, and you get to Supreme Court say, oh, the Court of First Instance lack jurisdiction, once that whatever it is. You got judgment in the Court of First Instance, that's judgment. You got judgment in the Court of Appeal. You got judgment in the Supreme Court, where is justice? So at times, you may have access to court, composition of the court, disposition of the judge, attitude of counsel may deny you access to justice in those courts. They are two different things. Thank you very much.
Thank you for
Sorry. Thank you for that. We learn every day and we learn every day. Thank you very much. We'll take that into consideration.
I want to do the job of the Okay. Yes, I want to. The guest lecturer says I should recognize this is Rocky Ajide. You are welcome. My job is done, right? One of the graduates is yes, okay, there's one of our donors here, so stand up for recognition, let them see you. Classmates from the guest lecturer. Yes, my dean, my mother, and my sister, thanks for the honor of bringing me back to faculty again, being chairman of the special occasion. I'm really glad. Thank you very much. Thank you very much.
Thank you very much, my lord.
Okay, at this point in time, we'll take Google messages from a few guests here. So the first person will be taking a Google message from is Alachi already. Okay, Alachi already has dedicated the Google message to my Lord Honorary Western Makomi.
Sẹ́yìn orí kó ti ń kú.
Now,